us all discuss about one of the most widely discussed and debated topic of the year, that is the Criminal Procedure Act of 2022. As you all know, this law was passed earlier this year. With coming in of this law, one of the colonial laws, that is the Identification of Prisoners Act of 1920, would be repealed. Okay, so the first question is, was the amendment necessary? So you can substantiate this by quoting few examples of the judgments of the Supreme Court or the suggestions which were given by the Supreme Court earlier. The court had suggested earlier that some of the provisions of the existing law must be widened. It had suggested to include palm impressions, specimen of signature or writing, and specimen of voice. Okay, so this will be a very important point in substantiating the new law. So what are the designated authorities at the central and the state levels? So every state is required to notify an agency which can store and preserve, which can collect and preserve the database. Okay, such records will be managed, processed and shared by NCRB, that is the National Crimes Record Bureau. Okay, so further let us see what are the concerns with respect to this law. So this law has come at such point of time where the judiciary has held that right to privacy would be considered as a fundamental right. You know, in this famous Puttaswamy judgment, it had held that any law or any measure which is intrusive of your privacy must satisfy three conditions. What are these three conditions? The first one is, it should have a legitimate aim of the state. Second is, it should be backed by the law. So these two conditions are being satisfied. It is because the legitimate aim of the state is to curtail crime by having a database. And the second one is also satisfied because it is backed by a law, because it's passed by the parliament. The third one is the most challenging. It says such measures should be necessary and proportionate. It is because you cannot quantify this. It remains challenge everywhere and even here too. So what it basically says is, any privacy intrusive law, if it is brought in, so if some proportion of your privacy is being taken away by the state, such or equally proportionate aim or objective of the state must be achieved. So this remains a challenge because this proportion cannot be quantified. Okay, there are some concerns or voices being raised against few new provisions in the new law, which has some provisions regarding the behavioral attributes of the convicted person. So this would further lead to predictive policing. So this is what the voice are being raised across the country. And one more is, they say that this law would be violating the Article 20 Clause 3, which talks about self-incrimination. That is, any accused person cannot give evidence against himself. Okay, so you can counter this by quoting one of the earlier judgments of the court, where it had held that any non-communicative evidence, that is, the evidence which does not convey information within the personal knowledge of the accused, cannot be considered to be leading to self-incrimination. Okay, so this does not remain a challenge anymore. Let us compare the earlier law which was permanent and the new law. So here let us see how the scope is widened in the new law. So let us see persons whose measurements can be taken. The earlier law says that that person should be convicted of an offence punishable with rigorous imprisonment of 1 year or more. Okay, such person who have undergone rigorous imprisonment of 1 year or more. But here it says such person who are convicted under any law. So this puts in further challenge for the state. Okay, this will require more infrastructure to store all the databases. So if a person is convicted for even some petty cases, what is the purpose of having the database of such people? Okay. So these are all similar provisions. So this new law basically widens the scope. Okay. So let us see the measurements that could be taken in the earlier law. Finger impressions, foot impressions, measurements and photographs. So under the new law, finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scan, physical biological samples and their analysis, physical attributes as I mentioned earlier, including signature, handwriting or any other examination. So this is widely being criticized, but you can counter this by quoting the judgment of the Supreme Court itself, where it had suggested to include the signature and handwritings in one of the earlier cases. Okay. And so the what we basically mean to say is that with passing of this new act, the government wants to have a database of this of the convicted persons for the time period of 75 years. Okay, so this will remain a challenge because this requires huge infrastructure which is not presently there in the country. Okay, I hope this video will be helpful to you. Thank you.